I'm going to draw out for you what would typically represent the administrative and also the criminal or courtroom findings on a first offense OUI in Massachusetts. The way that Massachusetts operates with an OUI offense is at the time of your arrest, you're going to see an administrative suspension, what I refer to as an ALS, administrative license suspension. It's administrative because it comes at you not through the courtroom or the judicial process, but rather it comes at you through the Registry of Motor Vehicles. Because at the time of your arrest, for instance, if you were arrested on January 1st, one of two things is going to usually happen in an OUI charge. You've either been asked to take a breath test, and at the time of your arrest, if you refuse to take that breath test, there's a response, and if you take a breath test that's over the legal limit, there's a response. If you take a breath test and it is greater than a 0.08, then your license will be immediately revoked for a period of just 30 days administratively as a result of taking the test over. Same arrest resulting in a refusal, however, will trigger a loss of license of 180 days effective immediately upon your arrest. So you can see the huge difference between taking a test over and refusing. Now, clearly, there is a reason why the legislature created the difference in the suspension periods. They want to force people into a decision where they take a breath test, because if a person is facing a potential 30-day loss of license versus 180 days, and these are graduated suspensions on refusals. If you have a prior OUI offense and you refuse a test, and they call this the CTR, the chem test refusal suspension. The CTR, if you have one prior, is 3 years. If you have two priors, the chem test refusal is 5 years. And if you have 3 priors and you refuse, the suspension is for a period of the rest of your life, a lifetime suspension if you refuse. Now, on a 3rd, 4th, 5th offense, if you take a chemical test and you test over it, it's just 30 days. So clearly they're trying to build into the system incentive for you to blow into that government breath box. During this period of suspension, there is absolutely no right to a hardship license. If you're revoked as a result of a refusal or testing over, you cannot get a hardship license. So that's the administrative process. Massachusetts does not offer a true hearing to challenge a suspension. You can request a hearing at the registry within 15 days, and that requires that you submit a written statement to the hearings officer as to why you did or did not refuse. They accept a faxed copy of a police report in response. In my experience, that process is not something that is generally worth going through because there's no real relief granted. These suspensions are typically just affirmed by the Registry of Motor Vehicles. Now, when you go to court, you're charged with a first offense OUI. In Massachusetts, that's a criminal act. It's a misdemeanor offense, and it has a maximum penalty of 2.5 years in prison. Strike that, jail. Now, that's the maximum offense, and I always tell people the maximums rarely, if ever, apply to anybody on a first offense OUI. If Charles Manson were to be granted parole in California, he broke parole, drove across country, got really drunk, and drove into a building in downtown Boston, he may in fact receive a 2.5-year jail sentence, but the typical first offender does not face any potential jail. Massachusetts has a drunk driving statute under Chapter 90, Section 24, and if you read that statute and it's reflected in the complaint that you have, it says that upon conviction, a first offense, you'll pay a $500 fine and have a 1-year loss of license, and that's what LOL is, not laugh out loud, but loss of license. That's if you're sentenced under Chapter 90, Section 24. On a first offense, though, however, almost every person sentenced receives the alternative sentence. And in Massachusetts, the alternative sentence is Chapter 90, Section 24D. That's the section that requires a 1-year probationary period and an alcohol education program. The loss of license under Section 24D is going to be one of 3 periods of time. It's either going to be a 45, a 60, or a 90-day loss of license. It's also going to require that you be on probation for 1 year. it requires that you complete the alcohol education program. And that program, as administered through probation, is 16 weeks. And then you have to pay all of the statutory fees and fines. And those fees, fines, program, supervision fees are going to run you in excess of $2,600. Now, if you are on probation and you are enrolled in the alcohol education program and you're up to date with your fees and payments, you can actually request, and if you can demonstrate to the registry a hardship, the Registry of Motor Vehicles will consider you for a 12-hour hardship license. That 12-hour license will carry you for the period of suspension imposed by the court, and also if this sentence is imposed along this timeline of the chem test refusal suspension, then the 12-hour license would apply for the court-imposed suspension plus whatever period of time you remain suspended on the CTR. If you're in the 30-day window and you take this disposition, then this 30-day suspension just terminates and ends, and all you have to deal with is the court-imposed suspension, and you can apply for a 12-hour license. You do need to demonstrate that you have either an employment, education, or medical hardship that requires or necessitates that you have 12 hours to drive on each and every day. They won't just give you a hardship license. If you live on the Green Line and you work on the Green Line and you can walk to the Green Line and get on the public transportation to work, you may not qualify for a hardship license. Now, the last part of this is that everybody in Massachusetts is eligible to ask the court to consider a certain type of disposition on a first offense OUI. If you were to go to trial on most first offenses and a verdict of guilty were returned, you're going to receive this sentence after a guilty finding. However, if you enter a plea prior to trial, you're most likely going to admit to sufficient facts, which is a form of a plea. And that's where you stand before the judge and you admit to the judge that there's sufficient evidence that if this were to go to trial, I could be found guilty. But because most people in this position don't have a prior record, it's a first offense, they can ask the court to continue the matter without a finding. And a continuance without a finding is a disposition that does not result in a criminal conviction, because literally the court says, okay, I accept your admission. We're going to continue this matter without a finding for a period of 1 year. During that 1 year, you'll suffer a 45-day loss of license. You'll be placed on probation for 1 year. You'll complete the alcohol education program, and you will pay the exact same fees and fines and have the ability to get a hardship license. If you successfully complete your period of probation, including the program, at the end of the 1 year, this case will be listed not only in the court record, but your probation record as dismissed. This is what is referred to as a QOF, C-W-O-F. And many lawyers will tell you the value of a QOF is really great because it does not result in a criminal conviction. In my practice, I am not someone who advocates walking into a courtroom in pursuit of a QOF on a first offense OUI, because it absolutely, although it's not a criminal conviction for purposes of state law, it absolutely counts as your first OUI event, because this drunk driving statute, Chapter 90, Section 24, states if you've ever been convicted, which is a guilty finding on an OUI, or assigned to an alcohol education program, then your next OUI is a second offense, which means this QOF is your first offense for the rest of your life, because we have a lifetime look back, and you've essentially given away a first offense where the sentence after trial is going to be identical but for the finding of guilty versus continued without a finding. I do not consider myself a plea escort service, someone who's going to walk you into court and pursue that QOF unless it's absolutely the correct thing to do to you. I am more an advocate of trying these cases to verdict because they can be tried. I have a very good success rate in obtaining acquittals. I don't win every case, and no lawyer should ever tell you that they've never lost a case. Otherwise, they don't really truly try cases. But the QOF is available readily on a plea, and it is going to result in an OUI finding that will be on your driver's history for the rest of your life and exposing you as a potential second offender for the rest of your life.